The first impression that comes to our mind about any college: tall buildings, big classrooms, large lobby areas, thick books, IT labs, assignments, class tests, and projects. Nothing besides that. Every hour, minute, second spent here help us carving and shaping our persona, cultivating innovative mindsets for the challenging world. Learning is a lifelong process. Sharing knowledge, inculcating values of life, spark the innovative horizons of mind. Fun and frolic is the nature of every nook and corner here. A daily dose of thrill we are sure to get here.
A very good afternoon to all those present here. I, Shruti Pandey, a second-year student of DME Media School, welcome you all to the 5th day of this one-week development program for students, DPS 2021. This 7-day program was initiated by DME Media School with the goal of academic and overall development of the students. Our guest for today is Professor Dr. Ambrish Saxena, Dean of DME Media School. He will be talking about the role of executive and judiciary during the second wave of COVID-19 in India. I would now like to call upon Coordinator Dr. Manasvi Maheshwari, Associate Professor of DME Media School, to deliver the welcome address. Over to you, ma'am.
Thank you, Shruti. Good afternoon, one and all. It is my great pleasure to extend warm welcome to all the participants on Day 5 of Development Program for Students 2021. Well, when we conceptualized this idea of organizing a development program for students, the aim was to provide a platform wherein students get to know how media industry has been redefined during COVID-19. And we at DME continuously work to provide best of learning experiences to our students. We invite people from industry and academia. So we consciously invited practitioners from all sectors of media during the 7-day program. The 5th session today will be conducted by Professor Saxena, Dean DME Media School. Sir, on many occasions, we have interacted and learned from your vast versatile experience. Today, we are privileged that through this series of DPS 2021, we formally have a session with you on the topic that really needs to be deliberated upon: role of executive and judiciary during the second wave of COVID-19 in India. In the pandemic, not only India, but the whole world is tumbling. All sectors are failing. All we can see is downfall and misery. And in such a situation, the 4 pillars of democracy, judiciary, legislative, executive, and media, what are they doing? What is their significance? Are they even playing their role aptly? Or they are busy in their own world of whims and fancies? This session of Professor Saxena will take us through all these points, and he'll address our queries, all questions related to the topic. So I once again welcome our speaker, all the students and faculty members on Day 5 of DPS 2021. Thank you.
Thank you, ma'am. Dr. Ambrish Saxena is a journalist turned media educator. Among many of his specialities, he is a prolific writer, eloquent orator, perky newscaster, an astute political analyst, and an expert on public policy and governance. A journalist at heart, Dr. Saxena has played a long inning in news media, having association with print, radio, TV, and digital media. He's a bilingual journalist having proficiency in English and Hindi and carrying experience of working on multiple platforms. Dr. Saxena has been working both on the reporting and the editing side, occupying positions of news editor, executive editor, chief reporter, bureau chief, correspondent, and an anchor. Dr. Saxena has remained associated with many radio stations of All India Radio. He has remained associated with newspapers like Amrit Prabhat, The Pioneer, and Newsleaf, and many more. He has worked as correspondent with Parak, India's first TV news magazine on Doordarshan during the year of 1991 to 1992. Now, I would like to invite Dr. Ambrish Saxena to begin the session with. Over to you, sir.
Thank you, Shruti. So today's topic, as has already been told to you, it is role of executive and judiciary during second wave of COVID-19 in India. In different sessions on different days of this development program for students, we have been trying to touch upon one particular aspect, but I have further narrowed down the topic that I have chosen myself. That is confined to whatever happened in the country during the month of April and May. And the latest thing that I have covered in my lecture, in my presentation, it's up to 7th of June. So it's a 2 months period which I have focused on, and the developments which have taken place during these 2 months as far as this COVID-19 pandemic is concerned. And I mean, whatever unpleasant things happen, whatever problems that we all witnessed, the deaths which happened during the last 2 months, almost, even if we go by the government data, close to 4 lakhs people have died, whereas as per the independent sources, the number is much, much larger. And we were all looking at the government, the central government and the state government, as to what they have been doing to combat this pandemic. At the same time, the judiciary came forward the way it had never came forward for the last 70 years. And as per the rough assessment, almost 15 high courts took a lead in doing something or the other to the benefit, to the relief of the people. So the whole thing was focused on the role of two organs of the state. One was the executive, that is comprising the central government and the state governments, and the judiciary, which comprises the Supreme Court and different high courts of the country. Now, in such a situation, it becomes necessary to examine this role, the role of the executive and the judiciary, and the relationship, the interrelationship of these two organs of the state. So to begin with, if we look at the Indian Constitution, and the students of BJMC particularly, they know a lot about Indian Constitution, because there are papers in the first semester, in the second semester, wherein something or the other related to Indian Constitution is there. So if we go by Indian Constitution, or otherwise also we talk about any democratic country of the world, there are three organs of the state: the legislature, executive, and the judiciary. And in one line, everybody understands that the basic job of the legislature is to make laws, and the job of the executive is to implement those laws, and the job of the judiciary is to pronounce judgment or to issue orders as and when something is brought before the judiciary. It can be brought by any citizen of the country in case there is a violation of the fundamental rights, or there is any such issue wherein a writ can be filed in any of the high courts or the Supreme Court. And as far as there's a dispute between the government or any private organization, those cases also are heard by any high court or by the Supreme Court. So judiciary becomes very, very important in Indian setup. Now, beyond this, if we try to look and understand this whole system which exists in our country, there is something which is called the judicial review. This is mentioned in our constitution. Judicial review is wherein any legal provision, any constitutional provision wherein there is a dispute or there is a conflict between the government or any other organization, then in that case also the judiciary comes to the fore. Otherwise, also, if there is an issue of an interpretation of a legal provision or the constitutional provision, there also the judiciary comes to the fore and the interpretation of that provision is made. That is what we call as the judicial review. So, what I am going to discuss, I will initially decide the questions or tell you the questions around which I will be revolving my discussion. So the first thing that we need to look into as to what is the main role of the executive and the judiciary, right? And if there are conflicting opinions expressed by any of the high courts or the Supreme Court, then what will happen or what happens? And then, as far as the policy making is concerned, whose domain is the policy making? Whether policy making is some such thing which is to be done by the legislature or by the executive, or it is something which is to be decided by the judiciary. Then another question arises, can a government say no as far as the implementation on a judicial order is concerned? Because number of such cases happened, if you remember, where in any high court would have said something and the government said that implementation on this is not possible. So what is the constitutional position with regard to this? And then if the judicial orders or the directions of a high court are binding in the entire country, because we understand that high court is in a particular state. But then if any Madras high court or the or the or if the Allahabad high court or Delhi high court, if they are saying something, whether that will be applicable in the entire country. Another thing which we need to understand, what is meant by suo moto. Suo moto is a very common term, but in the context in which I am talking about today, that becomes very, very important. And I must tell you, even at the outset, that the most important judgment, the most important direction, rather, I should say, which has been given by the Supreme Court on 7th of this month, that is something which is started as a suo moto action taken by the Supreme Court. And then PIL, because most of the high courts which were listening to, which were hearing to different petitions brought before us, they were in the nature of the PIL. So we need to understand this PIL. Now, firstly, I sent a few links yesterday. So referring to that, I will talk about the few of the judicial orders which were made by the high courts. So firstly, I will refer to few judicial orders which were made by Delhi High Court. I will refer to them with very, very brief, because I sent the link yesterday, so that you people should refer to that already, and I'm simply doing an interpretation of that. But then, as a reference, since everybody would not have done that exercise, the first judicial order or the direction which I'm referring to was given by Delhi High Court on 1st of June, and this was on the vaccination policy of the state. So here the High Court questioned the center's vaccination policy for not prioritizing the younger population. And it said that it is the younger people who are the future of the country. So this was very interesting. There are two judges, Jasmeet Singh, the bench was headed by Jasmeet Singh, who said that younger people are much more important than the older people. So they should have given the vaccine first. And irrespective of this, the government initially made the policy for 45 years plus people. And it was only as a correction of the policy which was taken by the government on 19th of April, that the vaccination was open to the people who were of 18 years plus age, and it was implemented on 1st of May. So Delhi High Court pulled the central government. Now mind it, any high court can pull the central government, which is executive, as I'm referring to. So they pulled the central government for making a policy which is not rational, which is not proper, and instead of safeguarding the younger people who, according to the High Court, are future of the country, the government did not give importance to them. Now, there is another judicial order which was made by Delhi High Court on 3rd of June. In this, very interesting observation or direction was made by Delhi High Court. They said that those who are responsible for scarcity of vaccination, they must be charged with manslaughter. there was much hue and cry on this direction. Now, what is manslaughter? Manslaughter is a term which, if we look into the legal terminology, then it is something which we call homicide. Right now, there are two types of, like in common parlance we call murder, but there are two parts to this. There is one part of homicide wherein it's not intentional, and another is intentional. And if I can give you a very easy example to understand this, if somebody is driving on the road and an accident happens, somebody dies, that's completely unintentional. Whereas there could be a conspiracy to kill a person. Some people make a plan and then kill that person. So they say that it's a kind of manslaughter. It's a kind of homicide. And people who are responsible for making a wrong vaccination policy, they should be held responsible for this. And to quote the language that the court had used, they said that there is a tearing emergency to fast track approvals and handhold vaccine manufacturers in the country. Now, what does it mean? The handholding of the vaccine manufacturers. So the court was of the opinion that it is the responsibility of the government to provide necessary help to the vaccine manufacturers, as the government has done lately, providing some advance amount to the vaccine manufacturers or providing them some money for research, as very recently the government has done about a week ago, that a third company besides the two companies which are already in vaccine manufacturing, they have provided 1,500 crore rupees to them so that they can complete their research and they can also manufacture the vaccine. So this was a very strange judgment by the Delhi High Court, and the High Court said that if the High Court did not name the government, but they said that all those people who are responsible for making the policy, if there is a responsibility found on their part, then they should be held responsible for this. In this case and in another case which was decided by Delhi High Court on June 4, there is another company besides this, Bharat Biotech and Serum Institute, which has been granted an order by Sputnik for the manufacturing. And this is a company which has been involved in a legal tangle with the government of India. And this company has had won a arbitration from the government, and the government was supposed to pay this company a handsome amount, but this company is Paneka Biotech. So this company is supposed to be paid 14 crore rupees, which is the arbitral award, which the High Court had already decided. But the government is not willing to pay that amount. So the High Court said that on one hand, the country is passing through a critical phase and the government is involved in these kind of legal issues instead of supporting that vaccine manufacturer, so the whole pace of vaccine manufacturing can be accelerated. Now, there is a judgment which was made by Kerala High Court on 24th of May. Here the government questioned, the Kerala High Court questioned the central government that why it is not providing free vaccine. Now, mind it, the policy which was made by the government on 19th of April, it said that the people who are 18 plus of age, they will be provided vaccine by the state government, and for that the state government has to buy 25% of the vaccine directly from the manufacturer for paying them. And then dual pricing happened. That same company was selling that vaccine to the central government at a different price, and to a state government to a different price, and also to the private hospitals at a different price. For them, the 25% quota was set. So Kerala High Court questioned this kind of policy, and they asked the government to rectify this policy. Now, another judgment of Kerala High Court, in this, the Kerala High Court questioned the state government, the Kerala government, that what is the target of vaccination. So the Kerala High Court said that there is no fixed target of vaccination for the state, and they said that the central government has not made that kind of policy or that number of vaccines wherein we can set the target as far as the vaccination is concerned. Another case which was again decided by Kerala High Court, wherein the court said that prioritize vaccine supply to states from non-governmental quota. Now, this was a case wherein the the government, the state government in High Court said that we are not getting the vaccine from the vaccine manufacturers, as the manufacturers are giving priority to private hospitals, selling them the vaccine at a higher price. So this was also questioned. The vaccine manufacturers were not giving vaccine to the state government. Instead, they were selling it to the private hospitals. So on this also, the Kerala High Court raised a serious objection, and they said that this kind of preferential treatment should not be there, and there has to be a uniform policy. Now, moving forward, if I can tell you a case which was wherein the direction was made by Gujarat High Court on 27th of May. Gujarat High Court pulled the state government, the Gujarat government, for the slow pace of vaccination. And High Court made this observation, had this remark that what you are saying in the court, it will be a 5-year plan. Means with this pace, the whole of the state will not be possible to be vaccinated within the time frame. So then another judgment, another observation or another direction which was made by Tamil Nadu High Court, wherein Tamil Nadu High Court, it's basically the Madras High Court it's called. So Madras High Court said that the center's allocation of COVID vaccine is somewhat disappointing. So they completely looked into the policy, vaccination policy of the central government and of the state government, and they said that this policy is improper, is not rational. Then two directions were made by Odisha High Court. In the first one, the this Odisha High Court said that why not to give the vaccine to the elderly people in their home only, particularly the people who cannot move out, and who are otherwise ill. So they should be considered as underprivileged people in the language of the court, and they should be provided vaccination in their homes. Another direction, which was this direction was made on 27th of May. Another judgment which was made by Odisha High Court on 27th of April, wherein it said that no prisoner be denied vaccination merely for not having identity document. Now you must be knowing that you, if you are willing to have the vaccination, you have to have the Aadhaar card, and you have to get yourself registered on the CoWIN app. So this has been raised, this point has been raised by many high courts and the Supreme Court, that this is something like creating a digital divide, and people who do not have access to internet or who do not have the identity proof, they will be denied the vaccination. Then talking about Bombay High Court, Bombay High Court looks into two things in two different orders. One was to examine the feasibility of door-to-door vaccination policy, right? And then they talked about there's another policy which was, it says give permission for door-to-door vaccination, right? So you must be knowing that even in the latest policy, the government has not decided about door-to-door vaccination. But despite this not being part of the government policy, despite this, you would have noticed many camps were being organized by private hospitals for profit making in the societies also. And in my area, there is an association of the societies, and the Max Hospital is providing all vaccination there. So, but then the government has not cleared this as a policy and has not allowed the state governments to look into this policy, right? And another order was passed by Bombay High Court, which was about ventilators, and the High Court said that if there are faulty ventilators and if the government is not able to fix that problem, then the government has to be accountable for whatever deaths are happening. Now, coming to Allahabad High Court, on 13th of May, Allahabad High Court said that the government has to have a foolproof plan for vaccination and also for the compensation. And number of clarifications was sought by Allahabad High Court from UP government, and the UP government was not in a position to clarify those points. Now, after these judicial orders, roughly I talked about, because as I said already, at least 15 high courts made different judicial orders at different points of time. And if I look into all the orders, the roughly the number might be 40 to 50 orders, which are practically not possible to refer to. So I basically talked about some of the prominent orders which were issued by the High Court. One a slightly unrelated case, but then since I said that I will be trying to analyze the relationship between the Supreme Court and the High Court. So this is a very vital case. This is a case which was taken up by the Supreme Court, wherein an order was passed on 10th of May with regard to a judicial order or the direction which was given by Madras High Court about 15-20 days back. And if you could remember, Madras High Court pulled the Election Commission of India for not making sufficient measures during the election rallies in the states where the election was happening, and not enforcing the COVID appropriate behavior, which resulted in heavy rate of infection. And very interesting remark was made by Madras High Court in that case. The Madras High Court said that the Supreme Court officials who are responsible for not doing this, I mean, not taking appropriate measures to check the spread of coronavirus, they should be held responsible for murders, basically, and the case will be taken up against them. What the court said, okay, I'm not getting the exact term, but it was like that they have to be accountable for the death of the people which has occurred because of this infection. And this Election Commission of India moved the Supreme Court of India against the order of the Madras High Court, and it said that it's inappropriate, and the High Court judges have used intemperate language against the Election Commission, so it should be impunged, it should be taken from the record. But so I refer to this case for two reasons. One, it's referred to in any case COVID infection. Two, it's between the High Court and the Supreme Court, and also if there is a constitutional institution involved like the Election Commission of India. So Supreme Court agreed with the petitioner, that is the Election Commission of India, to a limited extent, that the language that was used by the judges of the High Court was unwarranted, but it agreed with whatever High Court had said. And they said that the Election Commission, if the Election Commission is responsible for showing this kind of behavior, then they have to account for this. The language of the High Court might not be that appropriate, and they even advised the High Court not to use this kind of language against an institution like Election Commission. But they said if the Election Commission has done something which is seen as a lapse or an irresponsibility on the part of the Election Commission, then they have to account for that. And then they also did not agree with the Election Commission that this whole proceedings of the Tamil Nadu High Court should not be allowed to be in the public domain, because it's not in good taste. It is not, it is against the Election Commission. But with that also, the Supreme Court did not agree, and Supreme Court said that it is in the spirit of transparency and democracy that anything which is happening on the floor of the court, that should be told to the people. And one thing must be said here as a reference. One very major change that has happened happened in the proceedings of the high courts and the Supreme Court, that since this COVID-19 has struck, the proceedings are happening online, right? So, I mean, till 1.5 year back, anything which was happening in the Supreme Court or the High Court, the common people normally did not have an access, and they did not know as to what is happening there. But now, being everything online, so the Supreme Court said that in such a situation wherein everything is online, why the Election Commission is demanding that certain proceedings should not be told to the people and should be expunged. They said that it's for everybody to know what is happening in the High Court and the Supreme Court. This is an important observation in the light of the fact that we always talk about transparency in judiciary. So what Corona has done, that anything which is done by the judiciary is now very transparent. Okay. Now, another important case, very important case, which the Supreme Court took up and passed an order on 22nd of May. This is with regard to an order which was passed by Allahabad High Court, right? In one of the cases in a PIL which was there before the Allahabad High Court gave a long list of orders to UP government, and they said that every primary health center should have 4 ambulances. At every primary health center, there has to be an oxygen plant, there has to be ventilators and all. And UP government continuously saying this, that this practically not possible for us within 10-15 days. The High Court order was not possible to implement, but High Court did not listen. So the UP government approached the Supreme Court, and the Supreme Court came out with its order on 22nd of May. And the Supreme Court said that whatever High Court had said, that was in the right earnest, in the sense that the High Court judges were concerned for the woes of the people, for the miseries of the people. But then Supreme Court said it is practically not possible to implement whatever Allahabad High Court had said. So they struck the order of the High Court, and here the Supreme Court pointed out a very important concept in law, which is called the theory of impossibility. This says that no court should pass an order which is not possible to implement. Right? So, I mean, very interesting thing happened in the wake of this COVID-19 as far as the proceedings in the High Court or the Supreme Court is concerned. But then on the other hand, there is another case which was decided by the Supreme Court on 7th of May. This is referring to an order which was passed by Karnataka High Court. Karnataka High Court has passed an order in the wake of the scarcity of oxygen that the state government should make available 1,200 tons of oxygen every day in the hospitals of the state in Karnataka. Karnataka government moved to the Supreme Court that it cannot do so, but Supreme Court Supreme Court upheld the order of the Karnataka High Court, and it said that whatever might be the case, but then the Karnataka government has to make sure that all those facilities should be made available. So these are very interesting cases of the High Court and the Supreme Court, which I wanted to tell you all. Now, one very important thing which I will be talking about is the judgment of the Supreme Court, which was made on 31st of May. Now, one important thing which I said in the initially, that we have to understand what is suo moto, right? So suo moto is something which is done on its own, right? The High Court, any of the High Court or the Supreme Court, they can always take a suo moto action. It must be noted down, as I was telling you all, that the judgment, the most important order, rather, I should say, not exactly judgment, because judgment is something else, but what we are referring to as far as the High Court and the Supreme Court, these are called the judicial orders or directions. Right. So, I mean, the thing which I was telling you, even in the case of this Madras High Court, There the Supreme Court said that whatever Madras High Court has said, or in the case of Allahabad High Court also, the Supreme Court said that whatever Allahabad High Court had said, that should not be treated as judicial orders or directions, that should be treated as advice. Now, mind it, in legal terminology, I mean, there are different things conveying different meanings. So, if any observation is made, if any advice is made, that has a different connotation, and any judicial order or the direction is made, that has completely a different meaning, because that becomes binding on the governments or on the concerned parties, right? So, what is suo moto? So, I said this, that the Supreme Court, the latest order that was passed by the Supreme Court, the bench of Justice Chandrachud, Justice Nageshwar Rao, and Justice Bhatt, Ravinder Bhatt, it passed an order on 30th of May. And before that, in April also, it was a continuation. Now, mind it, this was a suo moto case. That is how I am referring to suo moto. You must understand such an important issue. The Supreme Court has taken as suo moto, and mind it, not any one judge has taken it as a suo moto. The Supreme Court has taken it as a suo moto. And the matter was, I mean, few judges approached the Chief Justice of India and said that we wanted to take up this case as suo moto. So this Chief Justice, he handed it over to this bench of Justice Chandrachud. So mind it, this has happened for the first time in the country. That such an important case, such an important issue has been, though suo moto happens very now and then, but it's a very vital issue which has been taken up as suo moto, not as PIL. So as I was explaining, that suo moto cases are the instances wherein any High Court or the Supreme Court use their inherent power of initiate the hearing of a case. They initiate a case and then they start hearing, right? Whereas all other cases which were being heard or which are being heard by any of the High Courts or the Supreme Court, they are in fact are PILs, public interest litigations. You must also understand the public interest litigations. Public interest litigations are the petitions which are filed, which can be filed by any member of the public for any matter of public interest. But here also you must understand, this is PIL, public interest litigation, but over the years, the Supreme Court and many High Courts have developed this opinion that in the name of the public interest litigations, the private interest litigations are taken up, and then that is how the Supreme Court and the High Court, they have started imposing fines on the people who had filed the PIL. Very interesting cases, some of you would have noticed about a week ago or so, just before the Environment Day, Delhi High Court came out with a judgment wherein they imposed a fine of 5 lakh rupees on actress Juhi Chawla. Juhi Chawla had filed a case against the implementation on 5G. And she pointed out that the 5G is detrimental to health, involving a lot of health hazard. And so the High Court should issue an order to the government for non-implementation of 5G. The court was so annoyed that this is no public interest litigation. You are doing it for your publicity, and imposed a fine of 5 lakh rupees. Before that, another case was, I mean, about 15 days back. All these are the very recent cases. Delhi High Court was hearing a case which was filed by 2 activists, and they had filed that case against this construction, this new vista which is happening, the construction of the Prime Minister's new office and all.
So Central Vista project.
Central Vista project. And the petitioners had said the court that this is something which should be stopped for the timing. They did not demand a complete stop. For the timing, by the time they said this second wave of COVID-19 is happening, and obviously it's not safe for the workers, for the laborers to continue with the work. So the work should be stopped. But The Delhi High Court took offense to this, that why anybody is raising a point on a project which is of national importance. According to the court, it was something of national importance, and then they imposed a fine of 1 lakh rupees on the two petitioners. Now the lawyers of High Court, they are collecting 1 rupee each lawyer to help the petitioners to pay that fine. So I'm telling you this, I told you these very interesting examples which happened during the last 15 days, which can tell you the finer aspects of this PIL. Okay, so I talked about the relationship of the Supreme Court and the High Court. And I also told you this, that what happens if something is not, I mean, this is one very common thing, that since Supreme Court is a higher court, is a superior court, whatever is says, it will prevail on whatever direction would have been given by High Court. But then most of the time in one of the judgments, because there are too many judgments, I cannot refer which judgment always. In the very recent case, the Supreme Court has even said this, that when a High Court knows that we are hearing a case on COVID-19 and related issues, why are they taking up that case now? Earlier, they would have taken up the case. But now, if they know that the Supreme Court is into this, so they should not do this kind of overlap. So, but lot of time, as I gave you some examples, the Supreme Court was endorsing the orders which were given by the High Court. So I talked about this relationship. Now, one important thing, the question that I raised initially, the policy making. The issue is that whose domain is the policy making? Now, if we go as per the constitutional provisions, it is the domain of the executive, or rather we should say the legislature as well, because laws are made by the legislature, by the parliament, but the policy making is done by the executive. In case the legislature is not there, like the parliament session is not there these days, and the government had to introduce a policy, had to announce a policy on the vaccination on COVID-19 during the last 2 months. So the government announced the policy. So the government means the executive has all the powers to do this job. And when the Supreme Court took this COVID related cases suo moto, the Solicitor General of India, Tushar Mehta, he raised this point in the Supreme Court, that why the Supreme Court is indulging into policy. He said that policy making is the executive job that has been entrusted by the constitution. Why the Supreme Court is involved in something which is a part of the policy, but the Supreme Court did not accept that argument. And here I am going to tell you the most important thing of the day, which we call as the dialogic judicial review. Dialogic is related to dialogue, right? Now, we know judicial review. I initially talked about that. But this is something which is completely a new concept, which all we must know. Whatever is happening in the Supreme Court these days, whatever many high courts are doing, this is part of dialogic judicial review. This is a concept which started from Canada, right? So it's not very much prevalent in the democracies of the world, but this is interesting to note. This has been put to implementation in India in the wake of COVID-19 and the issues of vaccination. What is this dialogic judicial review? Dialogic judicial review is in fact a means of placing important and uncomfortable issues on the legislative agenda. Now here, the motive of the Supreme Court is not to penalize the executive, or to do something wherein the executive is finding it difficult to answer. Though whatever the Supreme Court has done, the executive, the government is finding it difficult to answer. But the idea is to initiate a dialogue on the public policy. So for all those who take interest in legal things, for all those who are concerned for this COVID-19 and vaccination, who all are concerned for public policy issues and governance, this is something related to all these areas wherein the Supreme Court or any of the High Court initiate any such proceedings where a public policy is taken up and the government is pulled for making that kind of policy, and the loopholes in the policy are taken up. So this is what has been happening. The Supreme Court has questioned the pricing. The Supreme Court has questioned this paid vaccination for 18 years plus of age and free vaccination for 45 years of age. The Supreme Court has questioned that the involvement of the private hospitals and profit making by the private hospitals. The entire policy has been challenged. While challenging these, and mind it, thus what the Supreme Court has done on 31st of May, the Supreme Court has asked the government to present all that data on record. So what all the Supreme Court has asked for? Supreme Court has said, bring all the files related to policy making, bring all the file notings. Most of you must not be knowing about the file notings, or if some of you would have read properly the right to information, then reference would have come there, the file noting. Whenever I tell you in two lines, whenever the government is taking any decision, a file is moved wherein all the officials concerned, they made their notes. So there is a green sheet which is used, and on the margins of the green sheet, the notes are made on which date, which officer had said what. So if the file noting is brought before the court, the government will be completely exposed. And government was knowing this, that this is going to happen. That is how the government introduced a revised policy, the policy which was initially made in January, implemented on 16th of January. It was revised on 19th of April. It was implemented on 1st of May. And within 50 days, this policy has been revised by the government through a address to the nation by the Prime Minister on 7th of June. So this the government has done to save its face. And here you can understand the important relationship between the executive and the judiciary. If judiciary takes something up, the government has to pull back, the government has to take a back seat, and the government has to take all those necessary steps which are necessary to take in the light of the any high court or the Supreme Court judgment. Right. So I told you about this relationship of the executive and the judiciary. I told you about this dialogic judicial review. And I must tell you one more thing, because everybody must, because I provided all those links yesterday only. Everybody, if you have not gone through it, at least go through one important link, which is of India Live Law, wherein the order of the Supreme Court of 31st has been analyzed. Now, as I said, I repeat and telling you one more important thing. The Supreme Court took it up as a suo moto and as part of the National Disaster Act. And there is a provision in National Disaster Act which is about redistribution of essential supplies and services during pandemic. So Supreme Court has exercised its power under this, and the government had to change its policy. So all the things have been changed by the government, which were the points which were raised by the Supreme Court. One, the dual pricing has been abolished. There will be one price. The procurement by the state has been abolished. All procurement of vaccine will be done by the central government. So no dual pricing will be there. As far as private hospital are concerned, 25% is still reserved for a private hospital, but with the rider that they will charge 150 rupees as administrative charges, not like today, wherein the private hospital is buying a vaccine at 400, and if you are taking it in the hospital, they are charging 900. And if they are putting a vaccination camp, they are charging it 1100. So that will be over. So all these issues were raised by the Supreme Court, and now this has been changed. Right now, another link thing. What the Supreme Court has said also, the Supreme Court has talked about Article 14 and Article 19. These are again the things which you must know as journalism student, because you have been taught this. You have been taught the fundamental right. The Supreme Court said, referring to Article 14. Article 14 is about right to equality. So Supreme Court said why there is a discrimination against the people who are 18 plus. Because 18 plus people earlier had to pay for vaccination, and 45 plus people were not required to pay. So Supreme Court found it a discriminatory thing, and it imposed Article 14, and it said under Article 14, this is a discriminatory policy by the government, right? Article 21 also, the Supreme Court referred in this. So to what is 21? 21 is right to life, right? And right to life also involves, if you had a study, I think you would have studied as part of your syllabus, this also includes right to health, right? So this, if I can read it out, this Article 21 guarantees the life and personal liberty of all persons. It guarantees the right of persons to live with human dignity, which also includes the right to health. So right to health is part of Article 21. And if a fundamental right is violated, then obviously anybody can approach the Supreme Court or any of the High Court for the protection of that fundamental right. And this has been provided in the Constitution under Article 32, which is right to constitutional remedies. This means if any of your fundamental right is violated, you can move to the Supreme Court under Article 32. But if you do not want to approach the Supreme Court, you want to approach any other High Court, then you can do this under Article 226. So all these constitutional, because this was also raised, the central government raised this point before the Supreme Court, that why the cases are being taken up by the High Court when the Supreme Court is listening a case. Constitutionally, even if a case is being heard in the Supreme Court, even then a High Court can take up a case under Article 226. The High Court can never say no taking up a case, right? So I told you all this. Yeah. So I answered this executive versus judiciary. I answered High Court versus Supreme Court. I talked about the policy making. I told you how binding are the judicial orders, and when whether the government is bound by the judgment of High Court or the Supreme Court or order of the judgment. Yes, any government has to abide by that. No, otherwise there will be a contempt case against the government for not following the orders of the High Court, of any other High Court or the Supreme Court. I told you about suo moto. I told you about PIL. I told you about Article 14, Article 21, Article 32, Article 226, and I also told you the dialogic judicial review, which for me also, it's a completely new thing. And hats off to all the legal minds which are sitting in the Supreme Court, that they have brought some such thing which was until not implemented in India. So that is all. Now, any questions that you want to ask?
First of all, thank you so much, sir, for comprehensively explaining these so-called difficult concepts, although they are not so much difficult if we have so many things to read. First of all, about Article 14, Article 19, Article 21, Article 32, Article 226, and also this new concept, dialogic judicial review. So first of all, thank you for that. We have questions in the chat box, and although this is not directly related to the topic, but again, since this is in the news, so that's why Munna Safi is asking about the images of these political party leaders being printed on the certificate of the vaccine of a particular citizen of India. So what's your take on that?
See, whatever I will say that in the context of constitution and law. In my regular classes also, a number of such questions are asked, but I never answer a question from political perspective, because taking up any issue academically, because whatever I discussed, I never said this, that any state government was doing something wrong or the central government was doing something wrong. My whole emphasis was what was appropriate, what was desirable as far as the constitutional provisions and law is concerned. And the answer to Munna Safi's question is very easy. Any government can do it. Any government can take a decision. Now, this is the executive's domain. Naming the policies, like you would have seen, Prime Minister such and such a scheme, Prime Minister such and such plan. So it can always be done. It can be done with the Prime Minister, and Prime Minister by the post, whosoever is the Prime Minister, and then Prime Minister by name is always important because he is the head of the executive. So printing Prime Minister's name and photo on any document is completely in the domain of the central government. But I can tell you one interesting thing related to this. What is happening in West Bengal, if some of you know.
Yeah.
What the West Bengal government has done, West Bengal government in this vaccination certificate, because ultimately the vaccination is done by the state government. The policy can be made by the central government. Funds can be made available by the central government. Implementation is always in the hands of the state. This is very important to understand. I mean, to understand the relationship of the central government and the state government. And this is something which is very, very necessary to understand from the development point of view, or the planning point of view, or the governance point of view. And this is also necessary for you, student, to understand, because you might be having a paper in the third or the fourth semester, which is development communication.
So third semester.
Third semester. Yeah, so many of you would have studied. Those who are in the second semester, they will be studying it in the third semester. So for development communication point of view, it is very, very necessary. As I said, I repeat in just 2 lines. The development programs and policies are made by the central government on the recommendation of the Niti Aayog, right? In consultation with respective state governments. The plan is made by the central government. Funds are made available by the central government. The plan is then sent to the state government. Funds are transferred to the state government. Implementation is done by the state government, right? Same applies to vaccination. So the state is doing the vaccination, state machinery is doing the vaccination. It is under the supervision of the state government. So Mamata Banerjee, the Chief Minister of West Bengal, has played a trick here, and she is again right constitutionally, legally. She has started putting her own picture on the vaccination certificate. She is also right legally and constitutionally, like the Prime Minister is also right to put his picture. But then these are the interesting situations wherein both the Prime Minister has entitlement to his picture. The Chief Minister is also has also entitlement to the picture, and so the Mamata Banerjee as Chief Minister has exercised that entitlement.
Sir, another part of this question is related to that health as a subject is, I think, also part of the state government or the central government. I think that is also one question which you can please answer.
As far as I understand, this is in the concurrent list.
Okay, sir.
As far as I remember, this is the concurrent list. This means there are certain subjects. There are so many such subjects. I can even tell you about that. There are so many such subjects which are primarily taken up by the state, which are primarily under the domain of the state government, but the central government has a say into that. Health is not the only thing. Education is also that.
Yes, sir. Yes, sir.
Education is primarily a state subject, but then there is an HRD ministry, used to be HRD ministry in the central government. Now that HRD ministry has, so under the HRD ministry, the culture was part of it, the education was also part of this. But a few months back, this government has brought a change in this system. Now they have taken out culture as a separate ministry, and they have taken out education as a separate ministry, right? So and this is despite the fact that education is mostly under the state government. But you know that there is an UGC kind of institution, University Grants Commission, which is under the central government. There is AICT, All India Technical Medical Council, Technical Education Council, that is also under the central government. So these are the institutions under the central government. Also, there is a provision of making central universities, wherein the parliament is passing an act, though primarily the state assemblies are responsible for setting up universities, but then the state government is also setting up the central universities. So there is a lot of overlap in our constitution. And as I look at this, I think there is nothing wrong in this overlap till the point that cordial relationship is maintained between the central government and the state government. Problem is where that relationship is broken, and wherein there is a conflict, which happens in the case of so many states, particularly the states which are ruled by non-BJP political parties. They are always in conflict with the central government, and vice versa. Both ways this problem is there. Then there is a problem. Say for instance, if UGC comes out with something, and then any state government, any state university says that we will not abide by this, then there is a problem. Say for instance, if CBSE, it's a central institution under the education, they decided not to hold the 12th exam. Now, if any state government decides that we will hold exam, so if this kind, though it can do it legally, but then this will result into a conflict, that no board at the central level, at the state level is holding the 12th exam, and just state board of one state is holding an exam. So democracy is all about tolerance. Democracy is all about, there's a term which is used in the world of constitution and law, which we call checks and balances. And the beauty of Indian constitution is checks and balances, wherein one organ is showing restraint, one order is showing respect, one organ is showing tolerance to the other organ, and the conflict is avoided. Democracy is not about conflict. But then if conflicts are arising, then obviously the way out is the constitution and law, and only the Supreme Court and the High Court can show a way in such kind of cases.
Sir, another question is from our student anchor Shruti Pandey. She is asking, according to you, what could be the ways which could be opted by the government to make the situation better? Whatever the situation is as per today's time, how the government can make it better and improve the vaccination drive?
One, that whatever the Supreme Court has said, implement that in letter and spirit. Though majority of the things which the Supreme Court had said in its last order, the government has done it. But then beyond law, beyond constitution, there is something which is called politics. Unfortunately, in our country, politics dominate over everything else. So that is how this politics happens between the central government and the state government. And the interesting example of this is when there was a demand by the state, when the central government was procuring all the vaccines and were distributing vaccines to the states. So the distribution was not rational. Distribution was done by the central government. They were giving more vaccines to some states. They were not giving that number to certain other states. So there was a hue and cry in the states, and the states said that you give it to us and we will handle this, right? The central government readily agreed. Why? because central government said then, okay, take 20%, 25% of the overall vaccines, buy directly from the manufacturers. But very cleverly, the central government introduced dual pricing, meaning thereby the 50% which was being procured by the central government, they were getting at a less price, and the state government which was procuring 25%, they were buying it at a higher price. This was done cleverly, and the central government said that we have done whatever states were demanding. The prime minister has said on 7 कि हमने तो वही किया जो स्टेट्स डिमांड कर रही थी, लेकिन उसमें जो क्लेवर गेम था वो नहीं बताया उन्होंने. जब स्टेट को महंगा खरीदना पड़ा, देन स्टेट सेड कि ये तो मतलब इट्स अ फाउल, वी आर पेइंग मोर. एंड एट द सेम टाइम the government also allowed 25% to private hospitals. I refer to one case कि एक स्टेट गवर्नमेंट, केरल गवर्नमेंट भी गई मैन्युफैक्चरर के पास और प्राइवेट हॉस्पिटल्स भी गए. तो उन्होंने स्टेट गवर्नमेंट को तो होल्ड पे डाल दिया, प्राइवेट हॉस्पिटल को पहले दे दिया. Now these are the clever things which were played by the central government. Now if every government, central government and state government, they are playing tricks, they are trying to settle scores with the other, and they are trying to create conflict, then obviously there can be no solution to this. Otherwise solutions are easy. Solutions are in the last order of the Supreme Court. Solutions are in whatever former prime minister Manmohan Singh had said in April. So solutions are there only. Solutions are wherein the government make a wise policy, make a policy wherein doors are opened, which the government in a way has done now, opening the door for all manufacturers. There are total 7 manufacturers in the world. So the global manufacturers knocked the door of the central government in January. But Government of India said we do not need any foreign vaccine. हम आत्मनिर्भर भारत हैं तो हम अपनी बनाएंगे, हम अपना भी काम करेंगे, दुनिया को भी बांटेंगे. But that proved wrong within 2 months. So make a proper. Supreme Court has said this. Interestingly, if you can read the complete thing which happened on 31st in the Supreme Court has said this, that tell your policy makers to make a rational policy on what basis your policy makers have made the policy. In a way, Supreme Court has questioned the wisdom of the policy makers. So who are the policy makers? Policy makers are the government, the ministers, the bureaucrats, the secretaries, the joint secretaries, and also some specialized committees which the central government had set up. One important committee that was set up by the central government in April 2020, which Prime Minister has referred in his speech of 7th of June. तो उन्होंने ये तो बताया कि हमने तो कमेटी बना दी थी अप्रैल में, ये नहीं बताया कि उस कमेटी की पहली मीटिंग अगस्त 2020 में हुई. So if the government is not serious, then obviously nothing can happen. The government has to take up everything seriously. The government has to avoid any partisan attitude. The government central government, I'm saying all this, has to avoid conflict with the state government. The central government has to keep all their political benefits to the backyard and do the things in the larger interest of the people. And also the central government has to look into that. Ultimately, the policy is not made to benefit the big people, to benefit the big the manufacturers, to benefit the people with deep pockets, to benefit these big hospitals. If all this can be done by the central government, then a rational and pragmatic policy can be made, and we all can be comparatively more safe.
Thank you, sir, for that elaborate answer. Although we have some more questions, but I would like to ask and conclude this session by asking you about the kind of understanding which the students can develop. I know we have students from the 2nd semester also, the 4th semester also, and the 6th semester also. So I know you have been telling them that they should read the newspapers or any website or any radio channel, but how can they develop their understanding regarding this particular topic? And other than that, the role of legislature, the kind of not legislature, but the role of executive. The way we have seen in many videos that the collectors have behaved with the people. So, what suggestion or in this kind of situation where we are in, how should these executive or these bureaucrats actually behave when we know that we are in this pandemic?
This is something related to a long pending issue, which we call as administrative reforms, right? In India, for the first time, administrative reforms were taken up in 1966, and this is 2021. I will not say that reforms have not taken place, but it's majorly an eyewash. The structural reforms in the administrative setup of the country have not taken place. The mindset of the bureaucrats that has not changed, that is still of the British era, and no serious efforts have been made to change that mindset, to bring reforms in the working of the bureaucracy. So bureaucrats still believe, as they used to believe before 1947, that they are the kings. In fact, though we all the time look to the political persons, but the way the system has developed in India, basically the real rulers are the IS, not the politicians. They These bureaucrats enjoy all the powers, they make all the money, and they do all kind of wrong things. I will not say that they are not good people in the system. Obviously, they are good people, but then in bureaucracy, there are people who have hijacked the administrative system, who do the things that they like, and they have proximity with the politicians. Politicians mostly take decisions with the help of the bureaucrats, and that is how all this is happening. So, two reforms are majorly required. I do not know which party, which government will ever do this. One, the administrative reforms, another are the police reforms. Police reforms have not taken place. That is how cases like Hathras rape case happened in a country like India, even in 2021, when a rape happens and the rape victim's body is put to fire at the midnight. So even today this happens. So our police is like that, our DMs are like that, our ADMs are like that, and they feel pride in doing that because they know that they are reporting to the politicians who, I mean, what should I say? Who are completely? I mean, if there is a bureaucrat, there is a DG, there is a chief secretary in UP, and they know they are reporting to the chief minister, like the chief minister that UP has. So obviously they will do whatever they like. They know that who is sitting on top, so they will act as per the wishes of the chief minister and the home minister, and that is how they will do all kind of wrong things, and they will never advise the right thing to the chief minister or the home minister, because that could create a problem to them. So they are simply looking at their position, the post that they are holding. So basically, I mean, in the real words, the administrative and the police reforms is the need of the hour. So I do not know how long we have to wait, but till the time this does not happen, we will always be in trouble. Like the things which have happened in pandemic, if we are restricting ourselves to the pandemic, there have been reports from all across the country, from Azamgarh to Indore, everywhere, जहाँ पे पुलिस वालों ने, जिन लोगों ने, those who were not following the COVID appropriate behavior, जिसके पास मास्क नहीं था, उनको सड़क पे गिरा गिरा के पीटा, उनके हाथ पैर तोड़ दिए, सारा कुछ किया. So inhuman behavior with the citizens. So this will continue to happen if we do not reform. So it's unfortunate that we are not reforming even after 70 years of independence.
Thank you so much, sir, for enlightening us with your view regarding the role of the executive and judiciary in the time of this pandemic. Thank you so much. Shruti, over to you.
Thank you, sir, for your intuitive talk. Thank you, Mohit, sir, for moderating the Q&A session. I would now like to request all the participants to kindly fill the feedback form and receive their participation certificate. The link for the same has been provided in the chat box. I would now like to invite convener, Professor Dr. Susmita Bala, HOD Media School, to deliver a vote of thanks. Over to you, ma'am.
Thank you, Shruti. Good afternoon, everyone present here. Thanks, Dr. Saxena, for sharing so relevant information. Really, it's a fruitful and important session for all of us. This session was too informative, too knowledgeable, and enlightening. आपने इतने सारे केसेस और एग्जाम्पल्स के साथ जो भी शेयर किया, जो बताया स्टूडेंट्स को, आई थिंक स्टूडेंट्स को काफी बेनिफिट हुआ होगा इससे. एंड थैंक्स टू ऑल ऑफ यू प्रेजेंट हियर. थैंक्स डॉक्टर सक्सेना.
Thank you, ma'am. I would now like to thank Professor Dr. Ambrish Saxena for enlightening us today, and extended thanks to all our participants for joining the program and making it a huge success. It gives me immense pleasure to inform the audience that tomorrow, on the 6th day of DPS 2021, we would be joined by Ms. Hina Talwar, Senior Advertising Professional and founder of Firefly Community Hub, New Delhi. She will be joining us to talk about the changing face of advertising in the wake of COVID-19. Thank you so much for joining.
DME has embraced digital paradigm shift by adopting technology-based learning.
Unlike other colleges, we adopted a two-step strategy. In step 1, teachers would be preparing the videos, students would be watching them. In step 2, the student would be coming to the tutorial, clarifying the doubts, making the presentations, and discuss with the teacher.
At DME, we have invested in the best in the class academic ERP, which allows us to have a 360-degree robust communication amongst all the stakeholders, students and faculty members.
DME's virtual learning mechanism is no less than real-time classroom teaching,
wherein the students are provided the pool of e-learning resources in the form of PPTs, video lectures and online classes in a very student-friendly environment.
There is no need of mental blocks. Online teaching is as effective and interesting as offline teaching. Let the students enjoy this new mode of education.
In DME, we believe in quality education. We take care of our students. We want to see them happy.
Mental and emotional health are one of the most challenging issues of present times. DME Mentoring Cell takes care of that. Not just this, we go beyond academic curriculum to instill the most important employability skills in our students.